Police Court, I'm Heather Parker from Rutherford County. I would like to reserve maybe 7 minutes for rebuttal if I could.
7
Yes, Your
minutes?
Honor.
Okay. 7 minutes.
We are here today on an appeal from a jury trial out of the Rutherford County Circuit Court. This is a little bit of a unique position because I was not the trial attorney, but have handled the sentencing motion for new trial and the appeal. And so I would say a large quantity of our brief is a claim for ineffective assistance of counsel, which I don't normally see on a direct appeal, but because we had the evidence at that time, felt it prudent to bring it forward. There are issues that are raised inside of that context as well as outside, but I sort of plan to focus on that issue unless the court has other questions for me outside of that.
But before you get into the ineffective assistance issue, counsel, and good afternoon to you again. Does the ineffective assistance of counsel issues, and particularly with the testimony from, the credited testimony from trial counsel, that a lot of the failures to object were strategic, does that undermine completely then the claims for plain error with respect to the failures to raise those objections? I mean, you can't, not you can't. It seems difficult to meet the burden that the plain error factors are erecting.
Yes, the plain error standard is does carry quite a high burden. The thing that I will say about the strategic decisions is that the case law about strategic decisions is you can't make a strategic decision that's not based in some sort of research or investigation or preparation.
I don't think that's what the plain error factors, though, say. So the plain error factors say that you can seek plain error for an error that you didn't raise at trial, so long as there's not a tactical reason for doing so. And I don't think we're getting into whether it was reasonable or whether it was ineffective assistance. If you're making that call, plain error is not an option to avoid the waiver.
I certainly understand that, and I think my brief and certainly my argument to the trial court weighed pretty heavily on if this issue is waived, then we sort of move to this ineffective assistance of counsel area. However, for a decision to be tactical, that word, strategic, tactical, carries a definition that means that there's been some forethought put into it.
That's right.
That you hired an attorney who has an advanced degree who's there to represent you for a reason. And that reason is so that they can make those types of decisions. And when you look at, for instance, the decision not to object when the firearm issues come up, what her testimony was at the hearing on the motion for a new trial counsel's testimony, was that, well, on the one hand, I kind of wanted to avoid going into that because I didn't want to make it a bigger issue to the jury than just the one question that was asked, right? But on the other hand, she said, well, I didn't think there was anything wrong with that, with them knowing about this firearm issue.
And so that seems to imply, and I didn't mean to interrupt, that seems to imply that there was forethought. We may disagree with it. We may think if I were in that situation, I wouldn't have made that same call. But for plain error analysis, it seems clear that counsel's credited testimony was that she thought about it and had a reason for not pursuing a particular line. And that seems generally, I think, under the fourth plain error factor to pretty much to weigh heavily against granting plain error relief.
Except that in her actions at trial with regard to the firearm, she didn't avoid asking questions about the firearm like she said in her testimony at the motion for a new trial. She specifically started to ask the defendant questions about the firearm, which were then objected to as hearsay.
Okay, getting back into the ineffective assistance, I think I'm just focusing on whether the failures to object because they were not objected to are even eligible for plain error relief given the fact that she gave a reason for not objecting.
Whether we agree with the reasoning or not, I mean, it still sounds like a tactical issue that the trial counsel made.
I understand. I think that my reading of the transcript of the trial and her testimony at the motion for new trial hearing are inconsistent. And so I disagree with the trial court's crediting her testimony at the motion for new trial hearing because of the steps that she took during the trial don't belie the answer that she gave, which is that, well, I didn't want the jury to hear more about this. Well, but you asked more questions about it. So those two things don't equal to me. Like, that doesn't support her stated testimony for what the strategy was. Now, on some of the other points, I would agree with you that she stated a reason for why she did some of those. But with the firearm specifically, that testimony, it was very inconsistent what she actually did at the trial and then what her testimony for why she did did not object at the motion for new trial hearing. So
Okay, thank you.
I certainly understand that's a very high burden to meet under plain error analysis, but I raise that issue at a motion for new trial, certainly because if I don't raise it, it's gone. But I do think all of those things fit better under an ineffective assistance of counsel claim, because she should have objected. And that's one thing that Judge Turner and I agreed on, at least as to some points, that where the trial court did find that she was deficient, but he then found that it didn't prejudice my client, which I do disagree
Maybe I
with.
missed something, but you just said if you did not raise that at a motion for new trial, then it's gone. What about a true post-conviction petition alleging ineffective assistance of counsel?
Well, I mean, the plain error analysis section of it. Certainly, if I had not brought the ineffective assistance of counsel claim, then he could bring that later. But I meant the first issue with regard to the objections that weren't necessarily made at trial. Certainly, I suppose if she were handling his direct appeal, maybe they would not have made that argument. But
It's still there for post-conviction, though. I mean, you could, all the things you're talking about could have been raised for ineffective assistance in a post-conviction hearing.
certainly,
And you don't have the plain error hindrance in that situation. It's basically, did the lawyer, you go strictly on the lawyer's performance and establishing prejudice, which is another thing.
certainly.
But you don't have the plain error.
Right. I think they're two separate issues. They're based on the same fact, but I think this court can consider the ineffective assistance of counsel claim the same today as it could under a post-conviction hearing.
We can, but then you can't raise it in
That's correct.
post-conviction because it'll be previously determined.
That's correct.
That's the
Well, the whole
that's
claim,
difference.
yeah, the whole
Yeah.
claim of ineffective
Exactly,
assistance.
and things that you didn't raise would be considered waived because they could have been raised on appeal. So it's, it's like juggling hand grenades, but it's,
But in any event, you raise under the ineffective assistance of counsel claim each one of the failures to object, alleging that that was deficient performance and that it was prejudicial.
Yes, Your Honor.
Okay.
And one thing I want to make sure I hit is also the failure to investigate and failure to interview these witnesses. The entire case is a credibility case. It's, do you believe her or you believe him? That's it. There's no forensic evidence. There's no eyewitness testimony. That's it. It was very clear from the state's closing argument that even the state acknowledged that. And so I called at the motion for a new trial several character witnesses who were there to testify about my client's character for truthfulness. And that testimony came in. The judge acknowledged that he credited those folks and believed what they were saying. But then on the other hand said, well, I don't find prejudice to your client based on the failure to call these witnesses, which I don't understand why we would even be allowed to call credibility witnesses if they don't make a difference to the jury. Like if we cannot say these folks who knew him across different areas of his life for different number of years in different contexts, who would all be willing to come into court and say these things, how can we then say there's not a reasonable probability that the jury would have considered that? The victim, the alleged victim in this case,
Well, I think it's a little different though, right? Because it's not just that the jury wouldn't have considered it, it's that the jury necessarily would have given it weight sufficient to result in a different verdict.
that's correct. But when
So it's not just simply, okay, call them and the jury will consider it. But I think in the post-conviction case, the petitioner would have the burden to show that the jury would have credited it, would have given it weight, and would have caused it to overlook some of the other parts of the state's evidence.
the reasonable probability that it would have been a different outcome.
Right.
Yes. And so, but if all we have in the record is the state's victim's testimony and my client's testimony, those are the two things that we can weigh. The state was permitted to put in testimony from a classmate of the victims who talked about something that I also raised in the brief that never should have come in my opinion, that happened in class to corroborate or stand up the testimony that something happened here, as well as the testimony of her own mother, who I also alleged should not have been permitted, to show consistency or that to corroborate the victim's story. So why wouldn't we also want that same proof for the defendant, to show what something to uphold his credibility. And the jury wasn't given that option because this attorney, not only did she not, she didn't even interview the witnesses to see what they would have to say. And her stated purpose for that was, well, I don't ever call character witnesses because the state's cross-examination usually makes it pointless, which was not an excuse that I had heard before. But then the state began to ask those cross-examination questions at the motion for a new trial hearing, and I objected, and it was sustained because the cross wasn't relevant to their testimony. And so I don't know if there was some other cross that she was anticipating, but without having interviewed the witnesses to know what they were going to say, to know are they going to make it through cross-examination or not, how do you make a strategic decision to not call them as a witness? And so then you get to the point of, well, I have to show prejudice, right? And I simply think, can we disregard one witness who says this defendant is an honest and truthful person, as maybe just one witness wouldn't change a juror's mind or wouldn't be enough for a jury to set aside the rest of the evidence, right? Maybe. But there wasn't just one person. It's not just his brother coming in and saying he's a good guy, right? Like, these are upstanding members of the society who knew him from childhood, who knew him as an adult, who knew him through church, who knew him through work, very different walks of his life. And so, and the trial court credited all those folks. So I think we have to look at it as the trial court said these are credible witnesses. So we're not just talking about, is this witness credible or not? What would they say? I don't know. We know exactly what they would say, and the trial court's already made a determination that what they have to say is credible evidence. I don't know how the trial court could then turn around and say, but I don't believe that a jury that there's a reasonable probability that would have changed a juror's mind, because the only real way to get at that question is to ask a juror, which we've already heard this afternoon is really not admissible evidence. But it's the only issue in the case. Credibility is the only issue in the case, and direct testimony from, I believe it was 4 other witnesses on the issue of credibility, in my opinion, is the only way that you're going to impact a juror's thoughts in a case that weighs so heavily on credibility. And so I think if you look at that together with didn't interview this Alyssa Myers, who also provided this testimony that counsel clearly wasn't prepared to cross-examine. If you look at all of these things that counsel didn't do, the end product is what you've got is a trial where Mr. Davis didn't have a shot. I mean, he just, the cross-examination doesn't make sense. Questions that should have been asked weren't asked. This issue about the firearm, my client's mother had direct evidence about this firearm issue and was subpoenaed and sitting in the hallway and sequestered for the entire trial and then not called at all because his trial counsel had never even interviewed the mother to know what in the world she would have to tell the jury. So I'm not sure why she was sequestered if Ms. Laddyfogle wasn't prepared to call her as a witness at all anyway. But again, I've run out of time here, but I'll save the rest of my argument in response to what the state has to say. Thank you, Your Honor.
Thank you, ma'am. Ball.
Good afternoon, Your Honors. Ben Ball on behalf of the state. May it please the court. Judge Greenholz, I had a feeling that you would ask about the plain error issue. Just based on your discussion of the tactical waiver issue recently, and I'm going to butcher this name, but I believe it's Pewitt.
It's Pewitt. Or at least we think it is. We'd asked the lawyer at the argument, and I think the lawyer may have been unsure, but I think we all settled on it being Pewitt.
Well,
yeah, Judge Easter was on that panel. Yeah.
That's what I had assumed it to be, but so I had some of the same thoughts that you expressed about this interplay between ineffective assistance of counsel claims and plain error tactical waiver claims. And for years, this court, in the context of bringing an IAC claim, and both in a motion for new trial and direct appeal, had referred to this as the road fraught with peril. And I think over the years, it's been whittled down to focus more on bringing it for the first time on direct appeal, but it sometimes has been thrown out in regard to the motion for new trial. And I often had discussions with people about, well, what is the harm of bringing this at a motion for new trial phase if you have the evidence and you feel confident about it. And I think this may offer an illustration of what the problem
Well, and I
would
know
be.
there was an argument made not too many months ago in this court by an attorney, I think from the same jurisdiction, that it's easier to get an ineffective assistance claim on direct appeal than it is post-conviction, particularly when you're looking at it through the lens of plain error. Somehow plain error is easier than the high bar of that petitioners face in a post-conviction petition. So there's some thought out there anyway that it's easier maybe to get relief by doing it this way.
And until I encountered this case, that had occurred to me, with the exception of potential for waiving future claims and that type of thing. But here the interplay between these two things can be a bit problematic. And in this particular case, what you have here is for each of these claims of plain error for the admission of evidence. Frankly, I don't know how someone can demonstrate that claim when they put on evidence the motion for new trial hearing where the attorney gives a strategic explanation for the lack of an objection there. So
I think that's it, at least in the plain error context. And I think plain error is a pretty high bar to pass, generally speaking, because of this. But I mean, the whole purpose of that fourth factor is to keep litigants from playing fast and loose with the law, and that's withholding an objection in the trial court and then claiming foul on appeal. And where you actually have the lawyer get up in the motion for new trial and say, there was a reason I withheld the objection. You may disagree with it. You may think I was ineffective, but there was a reason. It's hard to believe that the courts, the appellate courts, then come back in and say, just on a plain error analysis, not ineffective assistance, but just on a plain error analysis, sure, we'll let you play fast and loose with the courts. You had a reason for withholding it, but we'll excuse it anyway.
right, I mean,
Particularly on an evidence issue, because typically evidence issues are not the type of issues that cry out for substantial justice relief. Typically sometimes they are. Typically evidence issues are not the types of issues where substantial right of the accused is at play. Sometimes they are, but typically not. And that's what we have here are evidence issues on plain error.
and you also typically have them reviewed for, it's an abuse of discretion standard, which, that's, what I think this court has said.
So help me with this though, General. So your friend on the other side, not conceding plain error, but moving strategically over to ineffective assistance. She says in particular with the character witnesses, and the strategic reason I understood about why trial counsel didn't call the character witnesses was I went to a seminar, and at a seminar they said, we don't generally call character witnesses because the state can undermine them through cross-examination. We ultimately look worse at the end of the day for having called the character witness as a result of that cross-examination. And so your friend on the other side says, but not this case, because in this case, trial counsel didn't even interview the witnesses. So we don't know what kind of character evidence they could have put forward, might not even know what kind of skeletons may be in the closet. She just made kind of a knee-jerk reaction. Typically in post-conviction, strategic questions are deferred to if they're supported by reasonable investigation. And it looks like, at least from your friend's argument, that the case here was simply a credibility battle purely and that no investigation was done. So my question to you is, what else supports the state's verdict other than the victim's testimony? Is there something that's corroborative? Is there other evidence out there? Is there something more than just diametrically opposed testimonies?
So, I mean, like many of these cases, this is primarily a he said, she said case. There is circumstantial evidence, however, that buttresses the state's case, and more specifically, I think the timing of how the allegations arose in the defendant's flight from the home, or I guess petitioner, I should say here, his flight from the home when he could not have known the nature of the conversation that the victim and her mother were having.
So there's corroborative evidence, in other words, that the jury could take and infer credibility placed more on one side than the other?
There certainly is. So this was not a pure swearing contest. I mean, obviously, credibility is always important in these cases. I don't think it was unreasonable of counsel to say, because she did reference training, she also referenced her experience, that bringing character witnesses in a case of this nature She had found it to be something that was not effective, and frankly, that makes a lot of sense. That simply saying, I find him to be an upstanding person is not going to dissuade a jury from believing that he could possibly do this. And I don't think it matters how many character witnesses they brought. I mean, there's a suggestion that it mattered because there was more than one character witness. I don't know that there's a number of character witnesses you can bring in that can convince a jury otherwise. These people have no actual knowledge of the events that took place.
I think that's true. I think in kind of the give and take in trial, there's a cumulative nature to it, right? There are diminishing returns. Your friend on the other side, though, is suggesting something a little more than that. And I think what she's suggesting is that in a case where you have close proof, that where maybe the state wins if the jury credits the victim, on the razor's edge, that maybe 1, 2, 3 credibility witnesses might make a difference. And that counsel couldn't know that until counsel interviewed the witnesses, just maybe based on experience in other cases, maybe helps inform the experience here, but not ipso facto. You'd have to at least talk with the witnesses before you can make the call not to call them.
So I would say that in response to that the closeness of the case does not change the maxim that we don't get to second guess the strategy of trial counsel. Whether it's a close case or not, that is a reasonable strategic decision to make. And frankly, I can understand that sort of sense that a jury might react to the presenting of just a number of character witnesses is all you've got is people who say they like you. And that's, it could backfire. I mean, this is the kind of decision that we leave to trial counsel and that we don't review, don't second guess in hindsight. And the question of the level of investigation of these witnesses, this was presented as a separate ineffective assistance of counsel issue. And if I recall, specifically on the petitioner's mother, there was a finding of deficiency there for not interviewing her, and ultimately finding that there was no prejudice because of her testimony would not have affected the outcome of the proceedings. So I think that those are really two different considerations:
Sure.
the trial preparation and then this specific decision whether to call character witnesses. And for my notes, I think we hit on 3, maybe 4 of the specific IAC allegations. I want to make sure that I hit all of them. The defendant alleged, my friend on the other side referenced the amount of sort of preparatory meetings with the defendant. This was a credibility contest, and the trial court here accredited trial counsel. I understand my friend on the other side disagrees with that, but it is not the position in this court to reweigh the post-conviction court's credibility. I mean, the trial court's credibility findings on this. We've discussed the character witnesses. I believe we also discussed earlier the testimony about the firearm, so I do want to talk about that. And this is sort of part and parcel of this. The firearm comes in the context of the flight from the home after the victim has disclosed what has been going on to her mother. And so counsel testified that it was a strategic decision not to challenge this, and that she didn't find it objectionable, but also didn't want to underline the flight. This was a reasonable position to take. I know that in the context of the plain error, the defendant contends that this was unfairly prejudicial, and this is why counsel should have objected.
She also mentioned that the trial counsel followed up with questions about this, and didn't just let it slide and let it be ignored, but actually proceeded with it.
There certainly may have been what could be perceived as a bit of a change in strategy there at some point. I mean, these are questions that are not on maybe the exact same tenor of this, and I don't know that there were any attempt to sort of underline the flight from the home and the nature that it took place. But I think it's absolutely relevant, and it's not unfairly prejudicial that he had the firearm. It's certainly no crime in this state to have to own a firearm. This was a firearm that was legally owned. As I noted in brief, many Tennesseans routinely leave the home with a firearm in their possession every day. This was not a crime. It was not a bad act. It was, however, relevant. And it was relevant to his mental state. It was relevant to guilty knowledge. So we have the victim's mother interrupts an encounter in a way that would not necessarily yield suspicion, but was somewhat suspicious, and she began to find it more suspicious as it goes on. She, defendant, I believe, made a sort of excuse of I was checking the locks or something, because he's sort of outside the victim's room. The victim's mother goes in, has a conversation with her, then packs up a bunch of her, clothes and drives her to a friend's home without explanation. I think in that context, and especially given that this conversation between the victim and her mother took place out of the defendant's hearing, his flight from the home immediately after that with a firearm was relevant to his mental state. So it certainly was not deficient for counsel not to object to that, and certainly the defendant hasn't shown that it resulted in prejudice. I believe I have touched on all the specific allegations of ineffective assistance of counsel that were addressed before, but I'm certainly happy to answer questions about any of the issues that your honors have, but otherwise I would ask this court to affirm the judgment of the trial court.
General, before you go on the consecutive sentencing issue, it looked to me like all the factors under 115B5, those were all, it looked to me like the trial court made specific findings on all those factors. Is that correct?
Yes.
Okay, all right, thank you.
Thank you. Ms. Parker?
I can't recall if I had time left or if I had gone too far over, so thank
I
you.
think you have 7 minutes, is that? 7 minutes.
I just want to address a couple of facts that were brought up in that argument. This idea about a flight from the home because he didn't know what the mom had talked to the daughter about, I don't think is supported by the record, because my recollection of the testimony was that the mother came back into their bedroom that my client and she shared to put on shoes or do something, and that there was a conversation between the two of them wherein he was accused, and then she leaves the house and he leaves the house. So I don't know about this argument that, well, he must have been guilty because why else would he have left the home? Because there was a conversation between the mom and Mr. Davis before he left the home. And so I would just say that I don't know that I agree with the state's assessment of the evidence as far as what corroborative proof that there may be of the victim's testimony. The other thing that I'll say is I've represented a lot of criminal defendants in this state, very many of whom wouldn't even be able to have their mother come testify that they're an honest and truthful person. So I do think that that's meaningful evidence when you have folks, especially folks who are not related to you, who are willing to come and not say he's a good guy. He's an honest person, because that's the only character that we're talking about when a defendant testifies. We're not talking about he has a penchant for violence or not. He's an honest person. So, and I think
Yes, that he would be believed on his oath.
that's correct. And so, and I think if you sort of look at what the state's cross-examination was going to be and what his trial counsel sort of thought about why she wouldn't call it character evidence, is that she was looking at it like the state just mentioned of, well, nobody cares if they're a good guy or not, because that doesn't mean that they wouldn't commit a crime. But that's not the evidence we're actually talking about. What we're actually talking about is, are they an honest person? And then the state can come in and ask, well, do you have a specific example of something that is honest that they have done? And I have had times where that has happened and yielded some very fruitful evidence, actually. But the state just got up here and said, talking, I think, about something different, but this is a credibility contest, which really just describes this entire case. And when the trial counsel testified and talking about her strategic decisions and why she did what she did, I still think in the ineffective assistance of counsel argument, her strategy has to be based on something. She can't say, well, I didn't call that witness because I never call witnesses. Well, you didn't even interview them to know that. But also, aside from that, if we look at Wanda Davis, my client's mother, who had information about the firearm and information about this victim making an inconsistent statement, which would have been a prior inconsistent statement, which is how it would have gone in even though it was hearsay. Trial counsel didn't even know that because she never even interviewed her to know. If you and to say, well, they only met in person one time. outside of the hallway of the courthouse. And that might work on a misdemeanor, but he got a 30-year sentence. And so the level of preparation there is underwhelming to me, and I think the ABA standards suggest that it should be much more significant than that.
And that may all be true on a
Yes.
post-conviction case. But going back with what Judge Greenholz was talking about is with plain error, which we're looking at. You know, all these things you're talking about the performance of counsel that we see in a post-conviction case, as Judge Greenholz talked about, if the lawyer comes in and says, this is the strategy I had, this is why I didn't object, you know, we're kind of stuck with that. And not, and this further analysis that you're talking about, which happens in post-conviction, does it happen in plain error?
I mean, plain error is based on estoppel, that the fourth factor is an estoppel theory, right?
Yes.
So, I mean, if you come in and say, I made a decision not to object, but now I'm gonna complain about it on appeal, it's essentially an estoppel issue. We still get to your issues in the post-conviction aspect of it,
Yes,
but,
I understand that. I think the only thing that I would say about the plain error side of it is, and Judge Turner disagreed with me, but I don't think her testimony at the motion for new trial, her being trial counsel, lines up with what she actually did at the trial. To say, well, my strategy was this, but then my strategy was I didn't want to call more attention to it, but then I asked more questions about it that were objected to, and no evidence ever actually came in before the jury because the question that she asked when she brought more attention to it was an inappropriate question. So I would implore the court to compare her motion for new trial testimony with what she actually did at the trial, because they don't comport to me. And the other thing that I would say is, the having a strategy for certain things about objections and non-objections applies to those evidentiary issues. But what strategy did she have for not interviewing Wanda Davis? She wanted to say, well, I didn't know that what information she would have. Well, of course you don't know what information she would have unless you interview her. And she sort of blamed it on my client for not telling her these things. But there are emails in the record from the motion for new trial where my client was saying, hey, you missed our phone call. When can we reschedule it? Hey, I want a meeting. Like continuing to try to reach out to this attorney. And what he ended up with was one in-person meeting the week before the trial. And so I think when you look at all of those things, the result of the representation is just the cumulative effect of all those errors underneath that demonstrate that on a whole, his constitutional right to an attorney just wasn't upheld in this case. So we would ask you to overturn the trial court and grant a new trial here. Thank you, Your Honor.
Thank you, ma'am.
I'm okay, yeah.
All right, let's call the last case then.
State of Tennessee versus Barry J. Zabileski Jr.